Have you ever heard somebody say, "My lawyer did nothing for me"? Well, I get calls all the time when people are facing sentencing or even after they've been sentenced, and they're calling me for help to fix their case because their lawyer did not do a good job. That's called ineffective assistance of counsel. And this is not the place you want to find yourself in. I will tell you, I'm always amazed that people will spend hours on Google trying to figure out the best restaurant to visit that day, even though they'll never step a foot in that place ever again. But yet, when it comes to their liberty, they're willing to hire anybody off the street, somebody who's probably never even been to a courtroom, or they will hire their distant cousin who failed the bar 3 times, but after all, he's family and he likes to argue. Don't make that mistake. Hire somebody who will do a good job for your case. But if something goes wrong, it's called ineffective assistance of counsel. We're now in the last video in my 10-part series where I've discussed 10 of the most important criminal law decisions and the misconceptions about them. We started off in video 1 and 2 about your right to remain silent and your Sixth Amendment right to a lawyer. We then talked about some of the illegal stops and what might happen in court at arraignment or a trial. In the last video, we've talked about sentencing, namely the federal sentencing guidelines and how they apply. And now in the 10th video, we're talking about post-sentencing ineffective assistance of counsel, meaning your lawyer did not do a good job. If you've been enjoying this video, this whole series, give it a thumbs up. If you're new to the LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to shop.lawstache.com and check out some of the merch, including these Do Not Arrest This Person t-shirts, hats, stickers, pins, and other items. And because you've been watching this series, type in the promo code 10cases to receive 10% off. Thanks for watching, and let's close out this series.
Quick message from LawStache. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vialtsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
In this last video, we're discussing 1984 Supreme Court decision Strickland versus Washington. Now, this case set a standard for ineffective assistance of counsel claim under the Sixth Amendment and the United States Constitution. The case was about David Washington, who pled guilty to 3 capital charges in Florida, and prior to sentencing and then later at sentencing, his lawyer failed to investigate and present any mitigating evidence, including character witnesses, Washington's difficult upbringing, and his mental state. He did not present any of that to the court. Washington was sentenced to death. Washington then appealed, saying that his lawyer did not do a good job. In fact, his lawyer did not provide any information to the court, and now it cost him his life. So he appeals, he sets it up for ineffective assistance of counsel claim. The case goes all the way up to the Supreme Court, and the Supreme Court uses this case to set up a new two-prong test to determine whether there's ineffective assistance of counsel under the Sixth Amendment. The first question is whether the lawyer did a reasonable job, whether the work that was performed fell below the professional norm, and we're using a reasonable standard. So first, we're looking at what did the lawyer do. The second part of the test is whether the decisions and the failures prejudiced the defense? Meaning, would the outcome be different if the lawyer did not fail to present that mitigating evidence? Or would the outcome be different if the lawyer performed his job at the norm? Now remember, this is a reasonable standard. And when we're talking about the professional norm, we're not talking about somebody doing a fantastic job or maybe even a good job. We're talking about a lawyer doing what's reasonably normal under the circumstances. The court also said that they're going to do high differential to the attorney, because we have to say that some of those are strategic choices. So sometimes the lawyers purposely don't present some of the information because they think it will hurt the client. So first we have to look at what the lawyer did, and then we have to look whether the outcome would be different. And here the court made a decision that Strickland, or Washington's lawyer, did not perform his job poorly. And even if he did, the outcome would have been the same. A few years later, in fact actually the same year, 1984, Washington was executed. And so this ends this series with ineffective assistance of counsel. I've presented to you 10 different cases that I thought were important. I think we've covered a spectrum of different topics in criminal law. Of course, there's many other topics, many other cases to discuss. We haven't even touched on capital punishment and executions, which we can after this case. But we've covered everything from the beginning of the case, through sentencing, through trial, and now ineffective assistance of counsel at the end. This brings me to what I've started this case with, saying that it is a high bar. It is difficult to prove ineffective assistance of counsel. And so do your research and hire somebody good from the start. I will close off this case with a quick story. I mostly do criminal defense, but once in a while I take a civil case if it's big enough and important enough. I've represented an individual who was being sued for $31 million. At the lower court, I won the case. A few years later, I was describing this case to a and this individual asked me whether I've ever considered that the person who was suing the bank lost the case on purpose just so they could set it up for appeal. And I said that I've never considered that, because I've never heard anybody losing the World Series because they're setting it up for next year. So again, before you hire a lawyer, do your research. This is your case. The time is now. You can't wait for next year. You can't wait until sentencing or appeal to see if the outcome would be different. You have to play your cards. You have to hire somebody who's going to do a good job for you. So thank you for watching this series. I hope you enjoyed it. We're going to continue on putting out videos every Wednesday discussing other cases. But if you've missed any of the 10 cases I've discussed, go back, watch the series. This has been 10 of the most important criminal law decisions and the misconceptions about them. If you enjoyed this series, give it a thumbs up. If you're new to the LAWSTACHE channel, which you really shouldn't be at the 10th video, but if you are, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to shop.lawstache.com and check out some of the merch, including these Do Not Arrest This Person t-shirts, hats, stickers, pins, and other items. And because you've been a devoted viewer watching this series, if you put on the promo code 10cases, you will receive 10% off. Thanks for watching, and I'll see you next Wednesday.